Court reporter, would you swear in the witness, please?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Good morning, sir. My name is Emerson Kaufman, and I represent Concord Consolidated in connection with some litigation that I'm pretty sure you're familiar with involving Edward Nixon. You are familiar with that litigation, are you not?
I am.
And have you ever given a deposition?
I have not.
And by the way, who is your attorney?
Christopher Baldwin.
And how long has Christopher Baldwin represented you?
December 19th, I believe, there's a document.
I'm sorry, December 19th of what year?
2015.
2015. So Mr. Baldwin began to represent you in December of 2015.
Uh-huh.
How many have you paid him for his services?
No.
You haven't paid him yet for any services?
Correct.
And you do intend to pay him, don't you?
I believe Mr. Nixon will probably pay him, but that's speculation. This is Mr. Nixon's case.
Okay. So let me go through some other rules of depositions. I don't want you to guess or speculate.
Then I can't answer that question.
Well, hold on a second. Did you sign a retainer agreement to retain Mr. Baldwin to represent you in this action?
Yes.
So you signed a retainer agreement, but for that retainer agreement, you paid not a dime. Is that right?
Correct.
So in the retainer agreement, and I don't want to know anything about the communications with him, but I just want to be clear that you have counsel representing you and you have no intentions, as we sit here today, of paying your counsel?
Asked and answered. You can go ahead and answer.
Yeah, I don't have any bills from him, so there would be nothing to pay yet.
Okay, you gotta listen to my question. I didn't ask if you had any bills. I asked if you ever had any intention of paying him for the legal services he is providing to you. And your answer, sir, is?
That I haven't thought about it yet.
So I just want to make sure the jury is very clear on what you're saying. You retained Mr. Baldwin about a month ago to represent you in this deposition in connection with litigation involving Robert Nixon, right? Right?
Correct.
Are you telling this jury that you have not thought about whether you will pay him, despite the fact that you have a retainer agreement with him in connection with this litigation? Is that what you're telling this jury?
Correct.
Now, do you have a joint defense agreement in this case, sir?
Yes.
And when did you sign a joint defense agreement, sir?
I can't remember exactly when it was. Prior to now.
Prior to now.
Uh-huh.
Can you be more specific when you say prior to now?
I'm sorry, I just can't remember when I signed it.
You can't remember. Then let's go back to each and every meeting that you've had in connection with this case, okay? Follow me? Do you follow me?
I'm following you, yes.
Let's talk about the first meeting that you had with anybody in connection with this case. When was that?
I don't remember exactly. I don't want to commit to something that I can't be absolutely certain is correct.
Did I ask you to commit to something that you can't be certain is absolutely correct, sir?
Yes, because I can't remember what the first meeting I had was regarding this case.
Excuse me, sir. Did I ask you to commit to something that you can't be absolutely certain is correct?
You asked me to commit to something that I can't. You asked me to answer a question that I can't be certain of the answer to.
Did I ask you to commit to something that is absolutely not correct?
Asked and answered.
Because if so, we're going to start all over again, because I know that I did not ask you to commit to something that is not correct.
That's not a question. Objection.
Right? You know I didn't. So answer the question. Did I ask you to commit to something that's not correct?
Objection. Asked and answered.
I believe I already answered the question.
Did I ask you to commit to something that is not correct thus far, sir?
Objection. Asked and answered. Asked and answered. Asked and answered. Asked and answered.
I believe I answered your question.
Then we're going to pose it a different way, because 7 hours, sir, I'm going to give the answers to my questions. Is there anything that I've asked you that would suggest to you, sir, that I want you to give anything other than truthful answers?
No.
So do you understand that all I'm looking for is the truth? Because you've taken an oath to tell the truth, the whole truth, and nothing but the truth. You do understand that, don't you?
I do.
And that is what I expect here today. I am simply going to ask you questions about information that you should frankly know about, right?
I'm not sure what you're going to do, but per what you just said, yes, you're going to ask me questions.
So let's go back to this joint defense agreement that you claim you don't know when you executed it, okay? Let's go back to that. Since you retained Mr. Baldwin, you testified on December 19th of 2015, less than a month ago. Is it fair to say that you signed the joint defense agreement between December 19th of 2015 and today, August 31 of 2016, sir?
That is fair.
So is there anything that you can think of that might refresh your recollection as to when you signed that joint defense agreement, sir?
Unfortunately not.
Who was present at that meeting when you signed that joint defense agreement?
Objection to the form. Mischaracterizes prior testimony.
Who was present?
Same objection.
I was present and Christopher was present.
And Mr. Baldwin was present?
Correct.
Just the two of you, is that correct?
I think I answered this question already.
Just the two of you, is that right?
I was there and Mr. Baldwin was there.
So Matt Mason wasn't there?
No.
Mr. Nixon's attorney wasn't there, right?
Just for clarification, I am Robert Nixon's attorney.
I'm sorry, you are absolutely right. Have you ever met Mr. Mason's attorney before?
Yes.
When did you meet him?
Once again, I don't remember the exact day, but we have met before.
Was it in between December 19th and today, August 31st of 2016?
Yes.
Was it in Mr. Baldwin's office?
I don't know which office is Mr. Baldwin's, so I can't answer that question, unfortunately.
Okay. Do you know whose office you're in right today?
This is a conference room of Stern Steinberg, is my understanding.
Right. Do you realize that Stern Steinberg, that firm represents you, or did you not know that?
That's my understanding, yes.
Okay, so then you understood, sir, that you were in the offices of your lawyers, did you not?
Objection to the form of the question.
The question itself was somewhat unclear.
Okay, let me
because-
clarify it.
Actually, you have to let him finish before what he's saying.
Did you want me to clarify?
You have to let me finish what I'm saying too.
We are in Georgia, so we are not doing speaking objections. You object to the form, and I'll clarify if the witness wants me to clarify.
But you have to let me finish my objection.
So you object to the form. I heard your objection to the form. Now I'm asking the witness. Do you want me to clarify the question?
But you have to let me finish what I'm saying. And my
Object to the
objection
form.
was not whether he understood it. My objection was that you interrupted him.
I move to strike.
Do whatever you want to do.
Do you understand my question, sir?
Do not answer the question until I get to finish my objection.
Go ahead, hurry up. Oh my goodness. Are you in first grade? Go ahead, hurry up, hurry up. Did you understand my question, sir?
Do not answer the question. My objection is that counsel for Stern Steinberg has interrupted the witness and then interrupted me while I was trying to voice my objection. So the objection that stands was that the witness was not given an opportunity to answer the question fully. I do not even recall through this last back and forth what the question was. I would like to have the question read back
No,
with the answer so that the witness can finish his answer.
no, you don't need to recall. I'm asking the questions. Sir, did you understand my question?
At this point, through the back and forth, I need the question repeated to me to make absolutely sure.
Perfect. That's a perfect answer. So let me pose the question to you again.
Sorry. I'm asking that the question be read back so that he can answer the question.
I'm going to withdraw that question, and I'm going to pose another question so that it's very clear. I asked you if you had ever met counsel who was sitting next to Matt Mason, and you said yes, but you couldn't recall when. Is that correct?
Per my recollection, yes.
Is it fair to say that you met counsel sitting next to Matt Mason in between December 19th of 2015 and August 31st of 2016?
I believe that I already answered this question, but yes, it is fair to say that.
So now we're going to go through every time you've had a meeting with counsel in reference to this case. You met on December 19th, 2015. When was the next time that you met?
And just let me make one clarifying instruction to the witness for the record. You are allowed to state, if you can recall, when the meetings were. You're not to discuss what was discussed in those meetings because we're asserting the attorney-client privilege over those discussions. But go ahead and answer it if you can.
Understood. We met about between a week and 2 weeks ago.
Between a week and 2 weeks ago. So that would have been over right before the New Year's holiday, right?
I'm not going to specifically state the day because I don't want to be incorrect about it, but
And how many times did you meet with counsel prior to today?
one time.
You met one time. So that was on December 19th, 2015?
Well, no, you said, well,
My question was, how many times did you meet with counsel prior to today?
uh-huh.
One time?
Well, I guess if you count December 19th, then it must have been twice.
So you met twice. And during those two meetings, you testified that at one meeting, it was just you and Mr. Baldwin, right?
Yes.
And who was at the other meetings?
This sounds like it has to do with the content.
Oh, no, it doesn't.
You can state the names of the individuals that were at the meetings. So you can state, if you remember, whoever was there, you can state that.
Okay, Mr. Baldwin,
Uh-huh,
myself,
uh-huh,
Mr. Mason,
uh-huh.
and there was one other participant, but I just don't remember their last name.
Was that participant a lawyer or from the lawyer's offices?
My understanding was that they were, yes, from the lawyer's offices.
So other than the first meeting between you and Mr. Baldwin and the second meeting between you, Matt Mason, Mr. Baldwin, and someone else from another lawyer's office, have you met at any time with your lawyer in connection with your deposition today?
Objection to the form of the question mischaracterizes prior testimony. Go ahead, you can answer.
Okay, for the last time, we are in Georgia, so you object to the form. The proper form is to simply object to the form. You were not supposed to say the basis for it because we've reserved that, unless you want to change the rules. Because if you want to change the rules, then what we're going to do is we're going to open up the other depositions, and I'm going to do objections that we're not going to preserve for trial. But if you're going according to the Georgia rules of civil procedure and the code of evidence, which you well know, I suppose, then you only object to the form. So my question is, if you remember my question,
I object to that, for the record.
Can you repeat the question, please?
Did you meet any, we've talked about the 2 meetings.
Uh-huh.
Did you meet any other time with your lawyers in connection with your deposition?
Not to my recollection.
Did you meet today? I saw you meeting today. Is that the 3rd time?
We are here today together.
Sir.
If you count that as a meeting, then yes.
Sir, I literally saw you with my own eyes, saw you meeting with your counsel. So my question to you is, did your meeting today, was that one of the 2 meetings that we referred to?
No.
So that's a 3rd meeting. So you had a meeting this morning. How long did you meet this morning in connection with your deposition?
Approximately, I wouldn't necessarily, once again, call it a meeting, but I understand that you were referring to it as a meeting, and I'm going to answer your question the best I can.
Who does Matt work for? Matt Mason?
Matt Mason doesn't have anybody he reports to.
What company does Matt Mason work for?
Well, I know that he works for Concord Consolidated, and I just don't know for sure. I haven't seen any documentation about him working anywhere else.
So you're not aware of whether, and this is what you were saying under oath, whether Matt Mason works for Rex Unlimited?
That is not what I said.
Are you aware of it?
That's not what I said. I said that I haven't seen any documentation.
Are you aware? I didn't ask you about documentation.
Sorry, he was answering the question about documentation.
I didn't ask you about documentation.
Sorry, I want to go back and let the witness finish his answer.
Why don't you go
He
back
said-
and make an objection?
I said I haven't seen any documentation, and there's a ... in the transcript reflecting...
Have you finished your answer?
Not yet.
Finish your answer.
I haven't seen any documentation like a payroll stub or other specific evidence, and I don't want to commit to something that I don't know absolutely could be true.
We've got a long time. We're going to commit to a lot of things. Let's focus on Rex Unlimited. Is it your testimony under oath that you don't know if Matt Mason works for Rex Unlimited because you haven't seen any documentation?
It's my testimony that I haven't seen any documentation that Matt Mason works for Rex Unlimited.
Is it your testimony under oath that you don't know whether Matt Mason, sitting right here, works for Rex Unlimited?
No, it's my testimony that I haven't seen any payroll type documentation of him working there.
So I just want to make sure that I'm clear, and so the jury is very clear on this. Is it your testimony under oath that there was a period of time that you did not report directly to Matt Mason?
During the time that I reported to Fred Carson was my boss per se. He was my supervisor. However, as previously stated in this company, and I'm sure many others, the president of the company is above all of the people below him.
When you reported to Fred Carson, isn't it true that you also reported to Matt Mason?
Like I said, my direct supervisor was Fred Carson.
Isn't it true, sir? I'm going to keep on asking this until you don't seem to understand some questions, so I have to clarify. Is it true, sir, meaning is it true or is it not true, that during the time that you reported to Fred Carson, you also reported to Matt Mason?
Objection to the form, asked and answered.
Do you understand that question?
I think I do understand the question.
Okay, so let's get the answer.
Can I repeat it back to you to make sure I do understand?
No. The way it works is Mr. Court Reporter can repeat it back. So, Mr. Court Reporter, can you repeat it back? Because the witness has some confusion about the question. So, if you don't mind.
I want to ask you this question.
Okay, the court reporter can't seem to find the transcript portion that I'm requesting. So I'm gonna ask you the question again. When you reported to Fred Carson, isn't it true that you also reported to Matt Mason?
The answer to that question is that it was told to me that I reported to Fred Carson. I'm somewhat unclear because this acquisition had, as far as I could tell, taken place at that point. So it was somewhat unclear, but my understanding was that my boss was Fred Carson.
So that if we have any correspondence, if we look through correspondence in your emails during the time that Concord Consolidated acquired Rexon Limited, there would be no direct emails from you to Matt Mason because you didn't report directly to him. Is that your testimony?
No.
Of course that's not your testimony. And furthermore, when you first came to Rexon Limited and you said you had another supervisor, you still reported directly to Matt Mason, didn't you?
When I had another supervisor, you're referring to John Baxter?
John Baxter or anyone. Anyone who was your direct supervisor at Rexon Limited for any time when you had another direct supervisor, you always reported directly to Matt Mason?
I would characterize it as reporting indirectly to Matt Mason during the times that I had another boss.
Will you mark this and give it back to me, Exhibit 1? I'm going to hand you this. I want you to take a moment and look at that. Tell me when you finish reading that email. So while you're reading, I'd like you to look at the bottom of the document. An email from Jeffrey Madison sent Wednesday, June 8th, 2011, 3:58 p.m. to Jessica Mason. You see that?
Wednesday, June 8th, 2011,
Yeah.
3:58 p.m. from Jeffrey Madison to Jessica Mason.
And you're Jeffrey Madison, right?
Yes.
Do you recall sending that email? Let me see if I can refresh your recollection. Jeffrey writes to Jessica, "You're the little bitch that slammed your door first and was rude, unprofessional, and obnoxious and distracting to the rest of the offices upstairs. You need to learn how to shut your, quote, fucking mouth and stop talking so much, quote, shit, like a 15-year-old girl and mind your own business. Thanks, thanks." Have I read that correctly?
I don't see any quotes in here, but it seems to be pretty close.
And Jessica Mason is Matt Mason's daughter, right?
Jessica Mason is Matt Mason's daughter. That's right.
And you didn't get along with Jessica Mason, right?
At times we had our issues. We also have times where we got along really well.
Well, you had a lot of issues with her. Let's look at your email to Matt Mason. And on Wednesday, June 8th, 2011, Matt Mason was your direct supervisor, was he not?
I don't remember.
You don't remember if in 2011 you reported directly to Matt Mason?
I think I reported directly, it's speculation, so let me just be clear about that. But I believe that I reported directly to Edward Nixon at that point.
Well, you were, as you just testified, he was the president of the company, so everyone really reported to Matt Mason, isn't that right? Or are you changing your testimony?
No, I didn't say anything contradictory. I said
So you reported to him?
He's still answering. I'm sorry. Please let him finish his answer.
Have you finished your answer?
Not yet.
Okay. Finish your answer and make sure you clarify whether you reported to Matt Mason in June of 2011, if you can.
Sorry. Just finish your answer to the pending question.
Okay, my answer to the question was that I'm sorry. Can we read back the beginning of my answer, please?
having a hard time following your own answer? Is that what you're asking, Mr. Court Reporter, to read back your own answer?
I need to put something on the record here.
Wait,
I need to put something on the record here.
You have to wait until I finish. That's the way it works.
No, I don't.
Yes, you do. Are you having a hard time remembering your own answer?
Don't answer that question.
Because Mr. Court Reporter can read back your own answer. In fact, Mr. Court Reporter, why don't you read back his answer, the last answer that he's having a hard time remembering?
Before you do that, let me go ahead and put my statement on the record.
Remember, it's Georgia.
We've had a number of instances where the attorney who is taking the deposition today has interrupted the witness, and then when I, who am representing the witness, made the point that the witness needs to finish his answer, Mr. Kaufman has then interjected with more commentary. And that has created a situation where there's often a long lag in time between the witness starting his answer and finishing his answer. And my request would be that we just allow the witness to finish his answer in the first instance. You may go ahead and read back
Mr. Court Reporter,
the question and answer.
the question. And I move to strike that as nonsensical. But if you would go back and read the witness's last answer, since he has difficulty understanding or remembering his own answers. Thank you.
Just to clarify, so there's no difficulty.
Then I will go back and pose another question. Go ahead, Mr. Court Reporter.
Just to clarify, there's been no difficulty in remembering questions or answers. It's just that they were interrupted.
Right. Go ahead, Mr. Court Reporter.
You're asking to read back the witness's answer.
Mr. Court Reporter is also having trouble remembering your answer. So let me pose a new question. Just so the record is clear, sir, isn't it true that during the entire time that you worked at Rex Unlimited, you reported to Matt Mason?
During the time that I worked at Rex Unlimited, everyone below the president, including myself, indirectly reported to the president.
So let's see what your response to the president was. This is an email dated Wednesday, June 8th, 2011, from you to Matt Mason, and you write, "I need this to stop. Jessica walked by my office earlier and I was working on something with Jim. I said, quote, 'It looks like Jessica has something to say,' closed quote, and she yelled across the hall that she could hear me and that I needed to stop talking shit, 3 question marks. Then I got up and shut my door and she reopened it and slammed it. She is a very manipulative person, and I'm sure she will twist this in her own way." And then you have in parentheses, "I can hear her doing it to our coworkers right now through my wall," close parenthesis. "And I really don't care, but I have some important items I need to complete right now, and it makes it tough when I receive emails like this. I believe this stems from what she said the other day about my attempt to, quote, 'run shit,' close quote, but I am not sure. There is one source of drama in this office, although most people are too afraid to say it. I really don't care about that either, but when it affects my ability to do my job, that's what I do care about. Please advise. Thanks, Jeffrey." Did you write that to Matt Mason?
It appears that I did. I don't remember the email specifically, but from this, it looks like one of my emails.
And do you have any reason to believe that you didn't send this email to Matt Mason on October 19th of 2011?
I don't have any reason to believe that I didn't send this email, but it indicates.
I know what this email indicates.
Sorry, he was answering the question. Can you read it back?
Okay, go ahead and answer the question. Then I'm gonna ask a question.
Read the question back so that he has it fresh and can answer the question fully.
Does this,
Sorry, I asked the reporter to read the question back.
okay, listen, I'm withdrawing that question, which is my right. Okay, so you just testified that you didn't send this email, right?
I don't think I did testify to that at all.
Mr. Court Reporter, since we have a slight amnesia issue, could you please read back his last answer?
Before you read it back, let me go ahead and make a statement for the record. Mr. Madison is not a party to this litigation, and he has appeared voluntarily to answer questions to the best of his ability. The condescending remarks of counsel for defendants and the suggestions that Mr. Madison hasn't been forthcoming or has selective amnesia are entirely inappropriate. We're going to allow the deposition to go forward, but I would warn opposing counsel to discontinue the habit of berating my client. It's entirely inappropriate, but go ahead, read back the question.
Not concerned about what you're saying, what you're doing, what you're saying. We're not stopping any deposition. If he hadn't appeared voluntarily, which you agreed to, we would have subpoenaed him and he would have had to appear as a fact witness. So all that bravado about this and that, we're not concerned about that.
Well, I guess you can weigh in with the judge later, but we're suspending the deposition.
Yeah.